Okay, this is the end of part 1, section 4, the annotated glossary of terms. Okay, cracking the code. I think we'll do each letter at a time for a video, and then just try to keep them short. Note: UCC means Uniform Commercial Code, per UCC section 1-104. When there arises a conflict between current code and a deleted section, the deleted section controls. That is to say, nothing is ever actually deleted. Therefore, early editions of the UCC would be helpful and useful. Introduction. Do not expect to understand the UCC at a glance. It is the culmination of thousands of years of effort by countless collaborators and was never supposed to have been deciphered. Understanding the code can be likened to solving a giant jigsaw puzzle. One is not going to see the picture with all the pieces in disarray. A few pieces must be connected before one can gain awareness of the fundamental issues at hand, build on them, and eventually solve the puzzle. But this need not take an inordinate amount of time. One good way to go about it is to follow the annotations accompanying the definitions of the terms that direct you to see and compare other related terms in the glossary. By gathering bits of understanding from different places and from different points of view, the pieces of the puzzle begin to fit together and the bigger picture can take shape very quickly. There are a number of key terms that will provide a good entrance point to the glossary for gaining an understanding of the redemption process. Some of those terms would be strawman, birth certificate, transmitting utility, value, redemption, and House Joint Resolution 192 of June 5th, 1933. An entertaining and all-inclusive definition is found at Wizard of Oz, the. Do not be daunted by the size of this glossary. All terms have bearing on what has happened and is currently happening, and thereby making it very interesting material for anyone concerned about survival and freedom. And here's a list of some of the dictionaries: American College Encyclopedia Dictionary, American Heritage Dictionary, Barron's Law Dictionary 3rd edition, Barron's Dictionary of Legal Terms, a couple of the Black's Law dictionaries, 1st edition, 4th edition, 5th, 6th, 7th, 8th, Bouvier's Law Dictionary, and Bouvier's 6th and 8th editions, Funk and Wagnall's Standard Dictionary, the Oxford English Dictionary, Uniform Commercial Code, Webster's Encyclopedia Unabridged Dictionary, Words and Phrases, which contains 90 volumes, and the Washington State Uniform Commercial Code User's Guide. Alright, on to the glossary. And we're just going to do this one letter at a time, and then for each video. Alright, ab initio. It's an adverb from Latin, from the beginning, from the first act. Black's Law Dictionary, 1st edition. Absolute rights. As regards right to interfere with contractual obligations of another, absolute rights, which individual may exercise without reference to motive, are rights incident to ownership of property, rights growing out of contractual relations, and rights to enter or refuse to enter contractual relations. By the absolute rights of individuals is meant those which are in their primary and strictest sense, such as would belong to their persons merely in a state of nature, and which every man is entitled to enjoy, whether out of society or in it. The rights of personal security, of personal liberty, and private property do not depend upon the Constitution for their existence. They existed before the Constitution was made or the government was organized. These are what the terms the absolute rights of individuals, which belong to them independently of all government, and which all governments which derive their power from the consent of the governed, were instituted to protect. Acceptance. The voluntary act of receiving something or agreeing to certain terms. In contract law, acceptance is consent to the terms of an offer, creating a binding contract, the taking and receiving of anything in good part, and as if it were a tacit agreement to a preceding act, which might have been defeated or avoided if such acceptance had not been made. The act of a person to whom a thing is offered or tendered by another, whereby he receives the thing with the intention of retaining it, such intention being evidenced by a sufficient act. An agreement either by express act or by implication from conduct to the terms of an offer so that a binding contract is formed. If an acceptance modifies the terms or adds new ones, it generally operates as a counteroffer. A negotiable instrument, especially a bill of exchange, that has been accepted for payment. Acceptance by silence. When the court implies a promise or holds that good faith requires a party not to violate these expectations, it is recognizing that sometimes silence says more than words, and it is understanding its duty to the spirit of the bargain is higher than its duty to the technicalities of the language. Acceptance for value. Note: by acceptance for value is implied a taking and acceptance of something in exchange for another thing previously provided. For example, a using credit balance previously established to purchase something. Value, as peculiarly defined within the UCC, is an esoteric term and implies that some sort of credit has been established beforehand, whereby the party with the credit may take, accept, purchase some item in commerce based on his credit, that is to say, what is owed. It applies in numerous types of situations. Basically, if a party has established his position as a creditor of some sort, he can unilaterally accept and purchase or take anything that would help reconcile the credit discrepancy by executing that particular transaction. Such a creditor, having essentially a credit balance, need not obtain anyone's approval before so acting. One example of this is the acceptance for value of a document bearing the creditor's trade name, for example, the birth certificate. The source of all credit and accountability or value associated with the trade name is the sovereign, the flesh and blood man or woman from whose true name the trade name is derived. Acceptance of a bill of exchange. In mercantile law, the act by which the person on whom a bill of exchange is drawn, called the drawee, assents to the request of the drawer to pay it, or, in other words, engages or makes himself liable to pay it when due. It may be by parole or in writing, and either general or special, absolute or unconditional, and it may be impliedly as well as expressly given. But the usual and regular mode of acceptance is by the drawee's writing across the face of the bill the word acceptance and subscribing his name, after which he is termed the acceptor. Parole, a word, speech, hence oral or verbal, expressed or evidenced by speech only, not expressed by writing. Okay. Acceptance of draft, certified check. A. Means the drawee's signed agreement to pay a draft as presented. It shall be written on the draft and may consist of the drawee's signature alone. Acceptance may be made at any time and becomes effective when notification pursuant to instructions is given or the accepted draft is delivered for the purpose of giving rights on the acceptance to any person. B. A draft may be accepted although it has not been signed by the drawer, is otherwise incomplete, is overdue, or has been dishonored. C. If a draft is payable at a fixed period after sight and the acceptor fails to date the acceptance, the holder may complete the acceptance by supplying a date in good faith. D. Certified check means a check accepted by the bank on which it is drawn. Acceptance may be made as stated in subdivision A or by a writing on a check, which indicates that the check is certified. The drawee of a check has no obligation to certify the check, and refusal to certify is not dishonor of the check, UCC 3-409. Acceptor. Acceptor means a drawee who has accepted a draft, UCC 3-103, subsection 1. The person who accepts a bill of exchange, generally the drawee, or who engages in a primarily responsible for its payment. Accommodation, an arrangement or engagement made as a favor to another, not upon the consideration received. Something done to oblige, usually spoken of a loan of money or commercial paper. Also a friendly agreement or composition of differences. The word implies no consideration. While a party's intent may be to aid a maker of note by lending his credit, if he seeks to accomplish thereby legitimate objectives of his own, and not simply to aid maker, the act is not for accommodation. Black's 6th edition, as a noun, number 1, a loan or other financial favor. Number 2, the act of signing an accommodation paper as surety for another. Black's 7th edition, see the note. Note, all of your licenses, permits, utility services, bank accounts, travel documents, W-4 forms, tax returns, paychecks, etc., are in your straw man's fictitious trade name, not your true name. Until now, when you signed any of these items, you are signing for accommodation and obligating yourself, albeit unwittingly, on the behalf of the trade name. Accommodation endorser, a party who places his name to a note without consideration for purposes of benefiting or accommodating some other party. Accommodation loan, a loan for which the lender receives no consideration in return. Accommodation maker, one who puts his name to a note without any consideration with the intent of lending his credit to the accommodated party. Note, when you sign a traffic citation, which is a promise to appear and then pay, that is to say, a promissory note, you are the accommodation maker, your straw man the accommodated party. Accommodation note, one to which accommodating party has put his name without consideration to accommodate some other party who is to issue it and is expected to pay it. Note, all promises to pay are done by accommodation. The flesh and blood man or woman signs the note for accommodation on behalf of the trade name. The fictitious straw man or trade name, an artificial person created by the government, is the transmitting utility. Thereby, all goods and services of the industrial society flow into and out of the possession of the flesh and blood man and woman. The straw man, having no life, no brain, and no body to which to apply a signature, must be accommodated by the actual attached man or woman, also known in this context as a surety. Accommodation party, one who signs commercial paper in any capacity or purpose of lending his name, that is to say, credit to another party to instrument. Such party is a surety. See note, surety. Note, when you sign a traffic citation, IRS Form 1040, etc., you are the accommodation party. You're the source of all credit for the party whose name appears on the driver's license, social security card, etc. in your possession. You have provided the trade name with value or credit your entire life. Account. Account, except as used in account for, means a right to payment of a monetary obligation, whether or not earned by performance. 1. For property that has been or is to be sold, leased, licensed, assigned, or otherwise disposed of. 2. For services rendered or to be rendered. 3. For a policy of insurance issued or to be issued. 4. For a secondary obligation incurred or to be incurred. 5. For energy provided or to be provided. 6. For the use of hire of a vessel under a charter or under contract. 7. Arising out of the use of a credit card or card charge. Use of a credit or card charge, or for information contained on or for use with the card. Or 8. As the winnings in a lottery or other game of chance operated or sponsored by a state, governmental unit of a state, or person licensed or authorized to operate the game by a state or governmental unit of a state. The term includes health care insurance receivables. The term does not include 1. Rights to payment evidenced by chattel paper or an instrument. It does not include number 2, commercial tort claims. It does not include number 3, deposit accounts. It does not include number 4, investment property. It does not include number 5, letter of credit rights or letters of credit, or does not include number 6, rights to payment for money or funds advanced or sold other than rights arising out of the use of a credit or card charge or information contained on or for the use of the card. UCC 9-102A2. See Consumer Transaction. Account number, see note. Note, same as account. Number 2. The sovereign creditor's mirror image private side of the governmental double entry bookkeeping ledger account number. For example, 1, 2, 3, 4, 5, 6, 7, 8, 9 without dashes. Of the strawman debtor's public side Social Security account number, for example, 123-45-6789. All IRS and state tax agencies correspondence reference the account number as the dashless version of the Social Security account number. Account debtor. Account debtor means a person obligated on an account, chattel paper, or general intangible. The term does not include persons obligated to pay a negotiable instrument, even if the instrument constitutes part of chattel paper. UCC 9-102A3. Accounting. Accounting, except as used in accounting for, means a record that is all of the following. A. Authenticated by a secured party. B. Indicating the aggregate unpaid secured obligations as of a date not more than 35 days earlier or 35 days later than the date of record. C. Identifying the components of the obligations in reasonable detail. UCC 9-102A4. Accusation, a formal charge against a person to the effect that he is guilty of a punishable offense laid before a court or magistrate having jurisdiction to inquire into the alleged crime. Note, per listing of informer/informant on the birth document and as subscribed thereto by one's mother, one has by definition had an accusation preferred against one. This is also very possibly the basis for all subsequent insistencies by Big Brother that the all capital letters trade name references the man or woman so identified by the birth document. Action, in the sense of a judicial proceeding, includes recoupment, counterclaim, set-off, suit in equity, and any other proceedings in which rights are determined. UCC 1-2011. See set-off. Adhesion contract, a contract so heavily restrictive of one party, while so non-restrictive of another that doubts arise as to its representation as a voluntary and uncoerced agreement, implies a grave inequality of bargaining power. The concept often arises in the context of standard form printed contracts prepared by one party and submitted to the other on a take it or leave it basis. The law has recognized there is often no true equality in bargaining power in such contracts and has accommodated that reality in constructing them. Note, a driver's license application and an IRS Form 1040 are examples of an adhesion contract. Admiralty, a court which has a very extensive jurisdiction of maritime causes, civil and criminal. Note, Admiralty courts, that is to say municipal courts, superior court, etc., comprise the only jurisdiction that can enforce a criminal penalty for a civil offense. No other type of jurisdiction has this capability. This is why people must post bail to arraignment or trial, or are sometimes sentenced to jail time, two aspects of criminal procedure, for civil offenses, such as traffic citations wherein no party is injured and no property damaged. All courts in America operate in admiralty courts. Admiralty law. The term admiralty and maritime are virtually synonymous. That's why people say maritime admiralty law. So it's the same thing. Affiant, the person who makes and subscribes an affidavit. The word is used in this sense interchangeably with deponent, but the latter term should be reserved as the designation of one who makes a deposition. See note affidavit. Note, as relates to the redemption process, affiant is defined as the natural-born flesh and blood sentient being whose name is designated in upper and lower case letters, one's true name, in accordance with the rules of English grammar, who executes and signs an affidavit under oath. Affidavit, a written or printed declaration or statement of facts made voluntarily and confirmed by the oath or affirmation of the party making it, taken before an officer with authority to administer such oath. See note, commerce. Note, the capacity to issue one's solemn declaration of truth, one's sacred word, is the most basic, fundamental, underlying, foundational concept of all commerce, society, and civilization. An affidavit is a written statement under oath, executed and sworn to before an authorized officer on the maker's commercial liability that all assertions contained within the affidavit are true, correct, and complete, not misleading, the truth, the whole truth, and nothing but the truth. An affidavit is the most solemn, unequivocal, and ceremonial means extant to express truth without evasion, concealment, deception, or insincerity. As distinguished from testimony, an affidavit is not subject to cross-examination and is intended to be a complete, self-contained document. All truth is subjective, and only each free will being possesses the right, duty, privilege, and capacity to state that affiant's own truth in accordance with the unique nature, perspectives, and priorities of the affiant. No one has the authority nor the ability to state the truth of another. As per the maxim of law, quote, the order of things is confounded if everyone preserves not his jurisdiction, unquote. Because truth is supreme in commerce, an affidavit is the most important document in commerce and stands as the truth unless unrebutted point for point by counter affidavits signed and certified on the executing party's commercial liability as the true, correct, and complete. That is the same, not misleading, the truth, the whole truth, and nothing but the truth. Exodus 20, verse 16, the 9th commandment states, thou shalt not bear false witness against thy neighbor, unquote. The Bible is especially harsh on those who bear false witness. Lies are weapons that are easy to utter, difficult if not impossible to undo when spread as rumors, and can destroy lives. People often act on what is told to them and kill or are killed on the basis thereof, such as by marching off to war, believing, quote, authorities, or blindingly obeying one's, quote, superiors, unquote. Caveat emptor is as wise an attitude in the field of words and ideas as it is concerning goods or services. For one's group official attempt at avoiding the consequence of bearing false witness, see Col Nidre. Affidavit of service. An affidavit intended to certify the service of a writ, notice, or other document. See note. Note. When using the mails, United States Postal Service for service of commercial process, it is always wise to include the original of an affidavit of service along with the item served. In so doing, one averts the potential claim by the recipient, I received the envelope, but it was empty. A sample affidavit of service is found in Part 2 under Handling Presentments. Agreement. Agreement means the bargain of the parties, in fact, as found in their language or by implication from other circumstances, including course of dealing or usage of trade or course of performance as provided in this code. Whether an agreement has legal consequences is determined by the provisions of this code, if applicable. Otherwise by the law of contracts. Section 1-103, UCC 1-2013. Compare contract. See note. Note, in other words, you have formed an agreement in fact and are inextricably linked with the trade name by course of dealing, usage, trade, and course of performance. The legal consequences of the marriage of your straw man trade name is spelled out in the code. Where applicable or not applicable, it references Section 1-103, which states that all other forms of law shall not supplement its provisions. The UCC is the supreme codified law on the planet. Legal consequences are dictated under the UCC. In law, and the UCC is the supreme law, there are only two kinds of people, debtors and creditors. All capital letters written. See note. Note. A proper name appearing in all capital letters falls outside the rules of English grammar, which authorizes the use of a capitalized letter only for the very limited number of well-defined uses, such as the initial letter of a proper name. A capital letter is defined as of letters of the large size used at the beginning of a sentence or as the first letter of a proper name. No lexical authority for use of the all capital letters is the name of a man or woman has yet been referenced by those who insist on corrupting the true names of men and women by displaying their name in all capital letters. An all capital letters written version of one's name is not one's true name, but an artificial construct, existing by the force of law only. No authority of English grammar recognizes such a contrivance. The legal term in propria persona means in one's own proper person. How can one do anything outside of one's own proper person unless there exists some other person by whom or which one could act? Using the jurisdiction or the juristic artifice known as legal fiction, parties identified in their proper noun name have been ascribed corrupted, all capital letter names. All legal pleadings, court records, and licenses use only names appearing in all capital letters, as to say newborn artificial persons, existing in the contemplation of or by force of law alone. See legal fiction, proper, fictitious name, artificial person, idem or informer. Okay. Allodial. Free, not holden of any lord or superior. Owned without obligation of vassalage or fealty. The opposite of feudal. Allodium. Land held absolutely in one's own right and not of any lord or superior. Land not subject to feudal duties or burdens. An estate held by absolute ownership without recognizing any superior to whom any duty is due on account thereof. Appearance. A coming into court as party to a suit, whether a plaintiff or defendant, the former proceeding by which a defendant submits himself to the jurisdiction of the court. Note, there are two kinds of appearance, general and special. See bail. Appellation. Calling by the name, title, pronunciation. Appealing. Appeal. Number 1. The act of appealing to a higher court or authority against the decision of an inferior court or of an inferior one, the appeal so made. B. Ground of appeal, title, claims. 2. The action of appealing or calling on, entreaty or earnest address. 2. Calling, designation. 3. The action of calling by name, nomenclature. 4. A designation, name, or title given, A. to a particular person or thing, B. to a class, a descriptive or connotative name. 1. A name or title. 2. Act of naming or calling. Acting of calling by name, a name or designation. Appealing, calling, naming, appellation. Accost, to speak, to first address, greet. Manner of act or addressing, greeting. Okay. Note. The significance of this term in your quest for personal sovereignty cannot be exaggerated. Appellation may be construed as simply a name, but its true meaning is infinitely more profound. Its actual meaning is that which is used by others for the purpose of gaining your attention. How you then respond after receiving such greeting or address is the prerogative of the sovereign. Art. A principle put in practice and applied to some art, machine, manufacture, or composition of matter. Artificial, created by art or by law, existing only by force of and in contemplation of law. Note, names of persons appearing in all capital letters are not written in English and exist only by force of or in contemplation of law. Persons so named are artificial persons. See juristic person, proper. All capital letters written. Idem sonens, fictitious name. Artificial person, see artificial, person. Assignee, the person or business to whom a security interest in collateral is transferred. Attachment, a security interest attaches to collateral when it becomes enforceable against the debtor with respect to the collateral unless an agreement expressly postpones the time of action. UCC 9-203A. See note. Note, depending on the type of collateral, a security interest attaches and becomes enforceable under different circumstances. See UCC 2-203 for details. Under previous Article 9, which is still essential in the harmony of revised Article 9, when the three basic prerequisites of a security interest exist, that is to say, agreement, value, and collateral, the security agreement became enforceable between the parties and was said to attach. Attorn, hence attorner. To turn to, assign, attribute, dispose, arrange, order, appoint, constitute, ordain, decree. To attorner, to turn. The analogical spelling is to attorn. But under the influence of medieval Latin, because attorner, hence attorn, passed into the English law books. 1. Transitive. 2. Turn over to another, to assign, transfer, goods, tenants, services, allegiances, etc. To transfer oneself. From one lord to another, to yield allegiance or do homage to as lord. 3. To agree formally to the tenant of one into whose possession the estate has passed, to do some act which constitutes a legal acknowledgement of the new landlord. Attorney, in sense of one appointed or one constituted, whence all the specific uses. The statement found in the law dictionaries for the last 200 years, the word means one who acts in the turn of another, is a bad guess. Number 1, one appointed or ordained to act for another. An agent, deputy, commissioner. In later times, only figuratively, and perhaps with conscience reference to sense 2, attorney in fact, private attorney, one duly appointed or constituted by letter or power of attorney, to act for another in business and legal matters, either generally and as in payment, receipt, and investment of money, in suing and being sued, etc. Or in such specific acts which the principal, by reason of absence, is unable to perform in person, hence the contrast in person and by attorney frequent. Alright, sense 3, a professional and properly qualified legal agent practicing in the courts of common law, as a solicitor practiced in the courts of equity. One who conducted litigation in these courts, preparing the case for barristers or counsel, whose duty and privilege it is to plead and argue in open court. An advocate, pleader, mediator. 5. Specific title of the law officer of various councils. Let's move on. Attorney and client. His first duty is to the courts and the public, not to the client, and wherever the duties to his client conflict with those he owes as an officer of the court in the administration of justice, the former must yield to the latter. The officer of attorney is indispensable to the administration of justice and is intimate and peculiar in its relation to and vital to the well-being of the court. An attorney has a duty to aid the court in seeing that actions and proceedings in which he is engaged as counsel are conducted in a dignified and orderly manner, free from passion and personal animosities, and that all cases or causes brought to an issue are tried and decided on their merits only. Duty not looked on lightly. Attorneys are, as officers of the court, have duty to maintain respect, due court, which duty should exceed that imposed upon the general or the public generally, and which duty should not be looked upon lightly, and cannot be shirked under the guise of representing interest of a party, litigant. Arm of state. As attorney is an officer of the court and as such an officer and arm of the state. Nature and duty of obligation. One who is admitted to practice as attorney at law, both by virtue of his oath of office and customs and traditions of the legal profession, owes to the court the highest duty of fidelity. Accepting employment entails duty to courts and faithful performance of services, vital public interest. The relation of attorney and client is affected by vital public interest. Letters patent. Right to practice law is a property right, existing by virtue of letters patent. 7. Corpus Juris Secundum 4, 1980. Practicing attorney, ability which is greater than that possessed by the average citizen. 7. Corpus Juris Secundum 29, 1988 or 1980. Accepting employment entails duty to the courts and faithful performance of services. And here's a bunch of references. Note, by definition, the obligations and duties of attorneys are toward the court and the public, abstraction of the mind that favors government, never to the client. Clients are fodder for the freedom usurpation and wealth confiscation activities of the court. Attorneys are there to ensure that the court is well stocked with paying customers. It is a rigged game, with attorneys enjoying many special privileges, such as having their fees enforced by judicial decree, even when they lose, in exchange for shepherding unwitting client victims into court at the sacrificial judicial altar. Clients are also wards of the court, and therefore persons of unsound mind. See Client Wards of Court. Attornment, a turning over, transference, assignment. 2. The transference of his homage and service by a tenant to a new feudal lord, hence legal acknowledgement of a new landlord. Authenticate. Authenticate means to do either of the following: A. To sign, B. To execute or otherwise adopt a symbol, or encrypt or similarly process a record in whole or in part with the present intent of the authenticating person to identify the person and adopt or accept a record. UCC 9-102A7. Aver. In pleading. To declare or assert, to set out distinctly and formally, to allege. Bail. By bail is understood sureties given according to law to ensure the appearance of a party in court. The persons who become surety are called bail. The persons who become surety are called bail. All right, let's stop there. And we can do the B's in the next video.